I just want to update everyone that we are deep in the budget process in county government. All the departments and agencies are working on their budgets. We had a good joint meeting with the cities and the county and the police chief yesterday about the police budget. And we'll be moving forward with all of our timetable as far as budget goes. So in last year's process, we had one preliminary budget and finance committee meeting on budget prior to this meeting. So this will be our first meeting. But the reason, as you all well know, is we are dealing with the ordinance committee discussion of the planning and zoning text amendments. So none of the work has stopped, but we just haven't been able to meet 1 week earlier, although that's not going to change any of our timetable. As you all know, my budget will be submitted to you by May 1st. We must advertise our LGEA and CRA funds, and the treasurer and I will work on that for a public hearing for you all to be aware about that. As we have done in the past, budget information will be posted online on our website in the transparency page. And then the fiscal court will meet to consider the proposed budget. That will be in a pre-meeting of the committee of the whole, and that is the first meeting in May. The first meeting in May, which is the second Tuesday of May. So the unofficial beginning of the budget process will be the receipt and acceptance of the jail budget. The detention center's budget will come to you by April 1st. I've talked to Jailer Rankin. She is diligently working on that and is well aware in her tenure of her responsibilities. So that will be a budget that you received. You all have received, or at least you will receive, the preliminary planning and zoning budget. You will receive the preliminary GIS budget. And as I did in the past, we will send you preliminary budget drafts from departments. And again, those are not those are not set in stone. Those could change. There may be additions, corrections, and then of course you'll receive the personnel spreadsheet as well. We do have the CASA request before you. I believe that CASA request is for $20,000 again this year. Has everybody seen that? Aware of that? I would just note that CASA service and work in Woodford County is really making a difference and doing a great job, and I think that you will see that appropriation in my budget. We've received a preliminary draft of the Bluegrass Community Action Program support budget. That could increase slightly as they look to give their employees some sort of cost of living adjustment or pay increase. For years, we didn't do that, but I recommend that they consider it, particularly that for years they didn't do that. So I don't think it's fair to ask those folks out there to not take any sort of increase, and it's a small additional approval. So I've asked them to consider that as they do in other communities. You've seen that the planning and zoning request, that preliminary budget, looks to be similar in the county's contribution of $112,461. We do know that the statutory obligation for funding the property valuation administrative office is $101,050. That seems to be the same as last year, and we anticipate that to be the same this year. I'm just going to go through a few things to refresh your memory. Our contribution to the police contracted services was roughly $2.2 million. We had an in-depth discussion about new police vehicles. Last year's appropriation in the budget was over $180,000. I do believe Chief Young is looking at moving away from the Tahoes and looking at some more affordable options. Something to consider. Police capital projects and equipment, we spent over or appropriated over $133,000. Parks and Recreation, our annual contribution of over $900,000. We do have the Parks and Recreation special capital projects. You all know that Big Spring Park is set to, the revitalization project is set to be complete. There'll be more expenses on that. And then we turn to the turf fields and some of the other county parks projects. I will say that when the turf bids are going to be solicited for the parks project, we are going to look at the turf for the community stadium. And I have had conversations with both the school board and the city about being involved in potentially including that as part of the special capital projects or a separate project, but the turf field at community stadium is in need of replacement and repair. The good news is that all of the preliminary work has been done many years ago, and all we would be providing is new turf and the rubber particles that go in the turf. So it's a much smaller project than, for example, the full practice turf field, the Logan Tipton field next to Community Stadium. I do have plans to present some of our economic assistance actions that we budgeted for the community. But you have other, you have the Woodford County Community Market Pavilion contribution of the county. That's $75,000 per the MOA agreed upon by the county to be paid by the end of the fiscal year. Dead animal removal. I've had conversations with the Soil and Water Conservation District about when they will present their budget. And Squire Varner, if you have any additional information on that, please let me know.
Judge, I just know they're working on their budget. I had at least 3 meetings on it, so they're getting closer.
Yes, sir. I appreciate that update. We've got our Woodford County Foundation Indigent Relief and Aid Fund, what we contribute for senior citizens. I was in a meeting of the cemetery board the other day, and they are looking at around a $6,000 project for tree removal at the Steele Cemetery, and they may be requesting the county contribute some to that. And if I get that officially, I'll share that with the court. But I do think that there's maybe some requests in the cemeteries and memorials maintenance from the cemetery board that will be included in the budget. We fund the food pantry executive director. That dollar figure is $75,000. We have a MOA with the cities where they will pay half. City of Versailles will pay half, and then Midway will come in this year and pay 5%, and that will come off the City of Versailles' expense. We have operational support under the public purpose statute for Woodford Wheels program. That was $10,000 in the current budget. The Woodford County Veterans Commission program support, we're looking at doing the Veterans License Plates program, which you all have heard about, that we're working out the details on as part of that program. We support the Mentors and Meals through public purpose appropriation, the Woodford Human Rights Commission, the Fair Board, the county support for the Fair Board. So those are some of the outside agencies that you can expect to see similar funding as we have in the past. Once we have our next budget meeting, we will likely set the date for the first reading of the ordinance for the budget, but we only have a couple options there. Obviously, those need to be advertised, and again, we're going to be go above and beyond in all of that. And we will have our second reading and adopt the proposed budget in our second meeting in June, the fourth Tuesday of June. That will be when we have the second reading of the budget. So we're working with the treasurer. She's hard at work on estimating receipts. We're working with all our departments on expenditures, looking at different liabilities and initiatives that we already have funded that we plan to continue to fund. We're working through all of our road funds and the cost allocation for those. You all are aware that we'll need to approve our standing orders, which our finance officer is working on. We had a meeting with Compass Municipal about our debt picture, and I think you all know this, but Woodford County government has the lowest historical debt burden that we've had as a county. Our bond rating is excellent, and our audits have been great as well. And so they have also been, what they do is that when they look into all that is they look into the projections of our potential receipts and things like that. So overall, the financial picture of our receipts is good. We obviously have to deal with the loss of the Yokohama payroll and net profits. We anticipate that will be, with the increase in jobs and wages in Woodford County, it really buffers us against the loss of those jobs, which will happen in May. But again, there's a lot of new jobs, new small businesses, new sources of tax revenue coming online, which really helps us to buffer that. I'd also add on that front that the EDA is hard at work in looking at how to strategically address that problem, and we are also involved in helping the employees at Yokohama find future opportunities. So we also have, as you all well know, a lot of grants in our budget. Some of those grants may be impacted by some things that are going on in Washington, D.C. We're monitoring that. But overall, our grant receipts are up, and they really help us fund our budget. I will go through the rest of our budgeting receipts and everything as we go through, but we'll have that for you. Thank you, Zoe. And but we're pretty much out of LGEA funds, even though we have to have that public hearing. We're pretty much out of those. We will have our vote on, very likely at our second meeting in April, our county road aid funds for our flex funds and secondary funds. You all are aware of what we vote on in those. Let's see. We have a number of mandated appropriations, the salaries of elected officials, and those must be set, Mr. County Attorney, which I'm sure you'll advise the court by May 1st.
Or the
First meeting in May.
Monday in May, so by the last April meeting.
Yes, Mr. County.
And Judge, that primarily would apply to the deputy coroners and the assistant county attorney.
Yes.
All right.
And in this budget, we also will address the magistrate compensation as it relates to an order by motion of the fiscal court in the last budget that if a cost of living adjustment is made for all of our employees, that it would also be allotted to the magistrates for a cost of living adjustment. I have not made it a decision yet on what I plan to present, but hopefully when the revenues and the expectations are that everything is good to proceed, that we would look at a cost of living adjustment in line with the 2.9%, which is what the CPI is this year. Retirement numbers actually go down this year, but you all are aware that our health insurance number is likely to go up. We don't know to what effect. We don't know how much. We're hoping under 5%, but it's just hard to know. But we will have that information for the court in the next couple of meetings, hopefully sooner rather than later. We have to appropriate the funds for the circuit clerk duties as ex officio law librarian for the county, for public defense, public defenders, the forestry, 50% of forestry receipts distributed through the road funds, and we have to approve our election expenses. And you all know this, the election expenses, there will be none in the first half of the fiscal year, at the end of 2025, and then the second half of the fiscal year we will have the 2026 primary election. So we will work with the county clerk on those. So I've gone over the main tenets of the budget, the things that have been worked on, the things that we are reviewing. So for the record, for the budget committee, you all have the CASA request, the Bluegrass Community Action preliminary request, planning and zoning's preliminary budget information, and you should have GIS budget information. Is that right, Madam Clerk? Okay, we'll send you GIS for your review. Appreciate Director Johns working on that, moving that forward. One thing I would note is that there's a lot of talk, particularly in Washington, D.C., about government efficiency and running an efficient government and demanding that we justify everything that we're doing. The fiscal court is DOGE. You all are the Department of Government Efficiency for Woodford County. If in this budget you find or see things, or in your time as magistrate, you see things that you believe are inefficient, it is an encumbrance upon you to bring that to the fiscal court. But I know in my day-to-day operations that I would put our government, Woodford County government, and the agencies that we work with and support, I would put us up against any government, particularly the federal government, in how well run, how efficient, how conservative, and how budget-minded we are. So as we go through, I want folks to feel free to identify things that you believe are areas that we need to look at. But I would ask that you work with the department heads directly if you have issues on that, and you can always contact me as well. So that is the beginning of our budget discussion for the fiscal year. I'd open up the floor for any questions or comments regarding the budget. Seeing none, we'll move on to the Young and New Farmer Grant Program. So we have some updates for you if you have that in front of you. And we have some decision items. So if you're looking at the spreadsheet, and Madam Clerk has done a tremendous amount of work in communicating with these young and new farmers, updating the spreadsheet, and distilling this information down to a decision point. So, we believe that for you today, number 16, 22, and 26, those are in gray in your spreadsheet, are prepared with the work of the clerk for their conditional approval. Is there a motion from the committee to recommend to the fiscal court same?
Motion.
Motion by Squire Darrell Varner.
Second.
Second by Squire Taylor. Seeing no discussion, all those in favor of the recommendation, please vote and signify by saying aye.
Aye.
All those opposed, nay. The motion carries. we have a decision point here. Farmer number 24 and 27, also in gray, are under the age of 18. We believe that they may still also need to register with the county to do business, but a policy decision that needs to be clarified is whether or not we would allow the parent or guardian to sign an agreement for the minor farmer in order for them to be eligible for the grant. Otherwise, they're eligible, but the law requires that we are not able to engage in a contract with someone under 18. And therefore, we would need their parent and guardian's signature.
Judge, it just struck me, so the payment, would the payment go to the parent or guardian on behalf of the child, or would it be made payable directly to the under 18 farmer?
It would be made payable to the farmer as they would be registered to do business with the county. So again, this would be a contingent, or excuse me, a conditional approval. But the recommendation would be the fiscal court allow parent or guardian signatures on the grant agreement to allow a farmer under the age of 18 who is eligible to be conditionally approved. Is there a motion to recommend that policy to the full fiscal court? Motion by Squire Taylor, second by Squire Varner. Open up the floor for any discussion.
Good for them. They're putting in the work at a young age.
Absolutely.
The judge, the applicants that we're talking about here, I know they're very engaged in farming, and this young farmer group cannot be pushed hard enough. I mean, we need more young farmers, so I think it's a right decision.
Great point, Squire Varner. One of the young farmers came up to me and they said, "I'm really sorry that I messed up the application." And I said, "You can only be as old as you are." So they thought that they were ineligible, but this policy change, if it's adopted by the fiscal court, would keep them eligible. So all those in favor, please vote and signify by saying aye.
Aye.
All those opposed, nay. Motion carries. Farmers number 33 and 34, their applications were received after the deadline of 12/31/24. And in all of our grant programs, we've not allowed a late recipient to be considered. So we need to make a recommendation to the fiscal court. I think if we recommended to extend the deadline or allow them to apply past the deadline, that could be problematic. So is there a recommendation to decline numbers 33 and 34 for late submissions? I'd open up the floor for discussion if you don't want to make a motion yet.
Sure.
Mr. County Attorney.
The judge and I discussed this beforehand, and I know the sentiment and sympathy is, oh, can't we just include them? All I'll say is this, that's a policy decision. If this deadline doesn't matter, none of your deadlines matter. And if you're going to make an exception, you can. Again, that's policy, but you might have to explain down the road, if you don't make it in another case, why you've extended it here and you didn't extend it there. That's all I would say. And again, I don't even know who 33 judge didn't share with me. I have no idea who the involved individuals are. I'm just talking from a general standpoint.
And this is obviously we don't know, we haven't done the budget, whether this program will continue. But if it does continue, we can make sure to reach out to these folks and say, hey, here's your deadline again. I want to also emphasize that we did a lot of work to get this information out. We sent it to our farm service agencies, the Ag Extension, the FSA, the Conservation District, all had applications. We reached out to farmers individually. We advertised it in the paper. We discussed it multiple times in court. We didn't put a opaque deadline on there. We were very clear that the end of the year was the deadline. And we promoted it and left it open for a long time, if that helps you all in your decision. So is there a recommendation on 33 and 34 for the program?
We have to stay with our deadline, unfortunately. I mean, we had that in our past grants.
Mike?
Just saying, unfortunately, I think we need to stick with our deadline like we did with past grants, and I hope that the program's successful and it's something we can do in the future, again, for folks that have a need.
So it would be a recommendation that the court decline 33 and 34 for being received, submitted after the deadline. That's your motion?
Yes.
There's a motion?
Second.
Second by Squire Varner. All those in favor, please vote, signify by saying aye.
Aye.
All those opposed, nay. Motion carries. Farmer number 17 withdrew, just for your information. And number 31, did they withdraw as well, Madam Clerk?
He's not viewed them as not eligible.
So they wanted, that 31 was asking for a clarification on the criteria. Okay, so number 31 is explaining that they lease their land to producers and does not believe that they meet the requirement of the agreement. So if the court agrees with that assessment, which that is our criteria. So if there's no objection, we'll inform 31 that that's her decision to withdraw, but you all have seen the grant agreement, and I don't believe that she would be able to sign that agreement. Farmer number 3, number 11, number 13, number 21, number 23, and 28, all are unhighlighted, were mailed formal letters asking them to provide more information on their agriculture operations as requested by the screening committee. And so we are waiting decisions on those. But this helps us move forward the Young and New Grant program in a way that is moving it towards its conclusion for the fiscal year. So with those decision points being made and being unanimously recommended from the Budget and Finance Committee, are there any questions or comments on any of the Young and New Farmer grants?
I have one.
Yes, sir.
On farmer number 31, there's a lot of opportunities through conservation to apply for programs that would help them on their journey with their farm.
Thank you, Squire Varner, and we'll make sure to share that communication with the farmer or the landowner. Seeing no other discussion regarding the Young and New Farmer Grant Program, we'll move forward to the indigent funding request. So to my knowledge, there has not been a situation like this that we've been in, either in this court or in the prior court. I can't speak for courts prior to, but I know that in our indigent burial, pauper burial discussions, it is rare. And the instance is that we have a local resident who passed away, and we have no next of kin or family or any party willing or that has come forward to be responsible for this individual. And that's a difficult scenario if you can imagine it, but it was it's been out there for some time. You all received the information and request from the coroner, Penny Baker, and it does not appear that there will be any next of kin, family, or responsible party otherwise that will come forward to claim any sort of responsibility for the deceased. That being the case, the coroner has requested that this individual undergo a process through circuit court to basically be deemed a responsibility of the county. Those court costs, Mr. County Attorney, I don't know the exact amount. But the coroner would need for us to approve an amount of court cost for them to request that the circuit court take this action. So, would it be a recommendation of the Budget and Finance Committee to the full fiscal court that we authorize the expenditure of the necessary court cost to apply for the applicable filing in relation to this indigent burial funding request? Motion by Squire Carl, second by Squire Taylor. Again, this is just a recommendation to the full fiscal court. Are there any questions or comments on that? Seeing none, all those in favor, please vote and signify by saying aye.
Aye.
All those opposed, nay. And the motion carries. So once the coroner, assuming the fiscal court approves this in fiscal court, once the coroner makes that request of the circuit court and it is granted by order of the court, then we will be responsible for the final dispensation of the deceased remains. So that decision is not before us, but I would say because that decision could need to be timely, because the deceased is in the coroner's possession and has been for some time, that we would maybe need to request an email approval of whatever expense cost that would be, which is very likely to be cremation. Does anybody on the Budget and Finance Committee have any objection to reviewing any potential cremation expenses and approving that via email? Question?
I know there was a bill this session on the issue of cremation and burial. I guess, is there any limitations on cremation eligibility on that for that process, or is it?
In my discussions and in the clerk's work on this, we can often get free burial plots for pauper burials, but then you still have the requirement of the opening and the closing, and that it usually exceeds cremation costs. So cremation is typically, and we anticipate it will be the lowest expense, but we're going to present that to you for a decision. We just don't have that information at the moment. And if there's no objection, we'll present that to you via email, and because of the timeliness of this decision, we would ask for email approval.
Thank you.
Seeing no objection thereon, that's how we'll handle that. So I'll open up the floor for any questions or comments on any of the items that we've discussed. Any questions on the budget or budget process as we move forward? Seeing none. So the Budget and Finance Committee will adjourn, and we will reconvene after a brief recess in the Ordinance Committee. It is 4:06. Let me just give you all an idea how things are going to go. We're going to go into the Ordinance Committee. We will have to be done in the Ordinance Committee by 5:15 to be in the community room to welcome your national champion Woodford County cheerleaders. And then we will come back up after that for our 5:30 meeting. So we'll take a 10-minute recess. We will adjourn, and then we will reconvene in 10 minutes. Thank you. All right, I'll call this meeting of the Woodford County Fiscal Court's Ordinance Committee to order. Madam Clerk, would you please call the roll?
Squire Downey.
Here.
Squire Blackford.
Present.
Squire Gill.
Here.
Judge Executive Day.
Yes. And so we are reconvening the Ordinance Committee for a fourth meeting, I believe, on the proposed zoning text amendments, Articles 2 and 7. We met last Tuesday for 2 hours to discuss a proposal regarding in-family conveyances. The Fiscal Court, prior to that meeting, in our last regular meeting, sent the proposed zoning text amendment back to the Planning Commission. And you all are aware of the extensive procedural history prior to that meeting. So we are reconvening, and we are, I believe, as indicated by the last meeting 1 week ago, we are prepared to make a recommendation, or at least to discuss the proposal of a recommendation to the full Fiscal Court to send to the Planning Commission. That being the case, I would open up the floor to begin the discussion on where we are as far as a proposal and a recommendation. Squire Gill, you're recognized.
Thank you. Since our last meeting, Assistant County Attorney Phyllis Mattingly gave some, kind of cleaned up the recommendations that we had made, and everybody received those in your email. So I'd like to go over those if I could.
Yes, and this is your proposal and recommendation as well, or you're just having a generalized proposal and recommendation?
These are the recommendations from Phyllis Mattingly. And they're based on the ones that we had made, but she made them up to make them clear. And they look pretty good to me, so I'd kind of like to go over there and see what anybody has any recommendations.
Okay. Yes, Squire Downey.
You have it?
Just to confirm, these are from the list that we discussed in the last meeting that you
Yes.
had, and this is, you're saying this took that list and kind of
Correct.
brushed it up, if you will.
Correct.
Got it. Thank you.
Thank you, Squire Downey. Madam Clerk, and we've disseminated this to everyone.
Everybody's got it.
May I make sure?
All right. Squire Gill, then you want to go over these recommendations?
Okay, number one, the applicant, and in parentheses is property owner, must be a Woodford County resident. That's number one. Just to clarify that, she added property owner. Should I go on?
Yeah, let's
No.
keep moving through.
Okay, and number two, an affidavit in a format approved by Planning and Zoning must be signed by the applicant stating that at the time of the application, all parcels are being used in a manner consistent with Articles 201 agricultural use of the Woodford County zoning ordinance. And if nobody has a comment about that, I'll move on. Number three, an in-family conveyance shall not be approved on a farm parcel less than 35 acres. A farm parcel of 35 to 49 acres shall be eligible for one in-family conveyance. A farm parcel of 50 acres and above shall be eligible for two in-family conveyances.
Squire Downey, you're recognized.
Is this, so this does look to be a slight variance from your proposal that had a 30 acre versus a 35?
Actually, it's the same. What mine said that the primary farm parcel may never be reduced below 30 acres.
Got it.
So
Okay.
to do an in-family conveyance, they'd have to have at least 35.
Okay, thank you.
Okay, and then number four, And I changed this one based on your suggestion at the last meeting, Judge, that we should consider private roads that are good roads. And I asked around, and I was advised that the way to word that would be the conveyed parcels must not be less than 5 acres, platted with legal frontage touching a platted right-of-way. Instead of saying just public road. That could be a public road or a private road.
So that's different from the number 4 that I have.
Yes.
So will you restate that, please?
It is, let's see, the conveyed parcel may not be less than 5 acres, platted with legal frontage, and in parentheses, touching a platted right-of-way.
All right. Questions or comments regarding number 4? All right.
And then number 5, both the primary parcel and the in-family conveyance lot must be held for at least 15 years without transfers after recordation of the deed conveying the in-family conveyance lot. Exceptions to this restriction shall be a transfer between the parties of the original in-family conveyance and a forced sale due to judicial action or death or bankruptcy.
And so,
That was the recommendation of Phyllis Mattingly.
and can you explain what that additional language, parties to the original in-family conveyance, what that is anticipated to contemplate?
I think it was brought up in the ordinance committee that it could happen that they might want to give the smaller lot, you know, the farm owner is aging and they might want the smaller lot, so they switch. You know, they might want the conveyed lot and give the farm to the kids, and they could switch that without, but that would be the only way they could transfer it. They couldn't sell it to an outside party within the 15 years, but they could convey it to each other.
All right.
Okay, and number 6.
Judge?
Yes.
If I
Sure.
do want to point out one thing, just when you see a for sale due to judicial action, that way you don't have to distinguish whether it's like a divorce or foreclosure. They're both lawsuits. They're both judicial actions. So it is probably best just to generally say judicial action than try to list various types of litigation.
That's fine.
Okay.
Thank you. I mean, is everybody okay with that? Okay, number 6, an in-family conveyance lot can only be conveyed from a parent to child, naturally or legally adopted, or from grandparent to grandchild. Natural or legally adopted is in parentheses after parent to child.
And Judge, may I comment on that, please?
Yes, sir.
I think it's important that if that's what you choose to do, you go with the language in that fashion and do not make a reference, for example, to family member, because it has a specific definition in Article 2, which is different, includes spouses and everything. So you don't want to say family member, you want to distinguish the family members, okay?
All right.
And then and lastly, the above restrictions shall be stated on an in-family conveyance plat and shall also be set forth in the deed transferring title to the in-family conveyance lot. Now, I had a question about this one. I'd like to ask Phyllis about it, but she's not here. Does that mean it has to be on both deeds? The primary parcel, the new configured parcel, and the conveyed parcel? Do you have to have a new deed for both, since you've changed the configuration of that primary lot?
So, in speaking from a real estate attorney perspective, you would not, there would be a question as whether or not the primary parcel could be required to state that in the deed, although it should be platted. The changing of the plat could then necessitate a new deed. But once someone has a deed, you can't, there's no way to, I guess they wouldn't be forced, they would be willing to give up part of their property in order to do that. That's tough.
So are you okay with that language? I don't know. I'm not a real estate attorney. What we had put previously was that it just must be recorded on the plat and in the deed, and the 15-year requirement commences upon recordation of the deed. So I'm not sure which of those would be more appropriate.
I think we would want Phyllis's clarification on that.
Does the county attorney have any thoughts on that?
I do not want to speak for her. We did not discuss that last line. But I think if you all decide, all right, Phyllis's last line. Squargill had a question about your number 7. Everything else, there's no question about. She wants to know if it applies to both. So do you want to restate your question, Squargill?
Yeah, I'm just reading off the last recommendation that you made. The above restriction shall be stated on any in-family conveyance plat and shall also be set forth in the deed transferring title to the in-family conveyance lot. So that would be on both deeds, the primary and the
Well, there would
conveyed.
only be one deed. Well, there would be the original deed. Let's say you owned 50 acres and you were creating an in-family conveyance tract. After it was platted, you would deed the in-family conveyance lot to your child or grandchild. That is the deed that would have the restrictions in it. There would not be a new deed for your remaining property. You would just own that. You already own that. The reason is when you do the plat, you show or give evidence of a division, but until you transfer it, there's not a title transfer. So the only deed that would be created would be the in-family conveyance deed. And that is the one that would need the restrictions on it. I can give you a prime example of that just happened today. I was reviewing a title, I won't call any names, a husband and wife deeded an in-family conveyance tract to their son. No problem with that. Although, interestingly enough, they deeded him more land than they kept, but that's another issue entirely. After 5 years, he then conveys it back to his mother, and she then conveys it on. But at no time were there restrictions in that deed. So had he chosen to deed it sooner, the buyer would not have known that there were restrictions, but I think the buyer would have had a title, there would have been a title defect because the restrictions were not in the deed, and potentially the buyer could have sought, a correction or redress of that. So that's why I say it should be in the deed, as well as on the plat. Did I answer your question?
Yes,
Okay.
thank you.
All right.
Yes.
Thank you, Madam Assistant County Attorney, yes. So, yeah, Mr. County Attorney.
One last thing. In the event that you all are going to make a recommendation that this be returned to the commission for them to consider these changes, you should clarify then that you would like to see them consider a new special provisions section, so 704.7D, to add a 704.7D. They have, it was under the old special provisions portion of the, and they still have a special provisions. They renumbered it, and it ends with a C. So you would ask then that it be, if they're going to be consistent with what they had done before, that they add it. It used to be 703, I think 7E, but or whatever, but that they added a 704.7D special provisions. Do you have the
That,
80? Do you have the one that just shows the new? If you all were going to adopt it, Squire Gill, that showed what it would be.
and you mean where it would be?
Yeah.
In the article? No.
You're asking that they consider
They're
asking
going to add a paragraph. Yes, they're going to add one paragraph.
a special provision 704.7D, a paragraph for in-family conveyances. Yes.
I am not sure where it should go because that section is for A4, small community, and this is in family conveyance, which would be separate.
I'm just saying what it was before. It was considered a special provision in the prior.
Okay.
In the prior, if you look at, yeah, it was under 7. Back then, the special provisions were numbered 702.7.
Okay.
Right. Do you have what has been prepared, the newest draft? Not that's underlined and everything else, Squire.
I have the newest draft, yes.
Yeah, we've the one that you all were going to consider.
Mm-hmm.
Do you have that?
Yes, I do.
Okay.
Yeah, we have that.
Oh, I'm sorry. It is, I've got the old one versus the new one. 702.7, I wrote the old one from the red line. 702.7E is what it would be, consistent with what they had before where it was a special provision.
Okay. Underneath rural residential.
Yes. Or no, that's under, let me see.
Agriculture.
Do we really have to specify to them?
Just say a special provision.
Okay.
It was a special provision, just say then, and they can determine the numbering. And there is one more numbering thing, by the way, you do want to recommend when you send this back. So just say then, special provision for in-family conveyances. Then do all of this. But since you're sending it back, if you'll recall, I believe you brought up very early in the process, them saying apartments rather than dwellings. And there are 2 references to that. That was in 704.4 B and F that you wanted changed, I believe.
I think, is it 701.9?
Let's see. God, let me make sure of that numbering. 70.
Because this is where the old family conveyance was.
Yes, B and F under 704.4. B and F, line 2 in each to change dwellings, apartment to dwellings. They did do it in B. They did not do it in F. If you look on page
What?
704.4 sub F, they actually had it in sub B, but they changed that. But then they didn't change it in F.
I don't see an F in the one that he gave us.
It's on page 21. You're not looking at what I'm looking at.
No, I'm looking at
Okay.
a different thing.
And I don't think you're looking at what,
I'm looking at
it's
the most
the,
recent one we
it's
got.
the clean copy.
Yeah. So many.
Do you have that?
Yeah, this is what they gave us at the last.
It's what I gave you all, not what they gave you all.
Seven,
We took out all the deleted and the underline, and it was, that's very minor, but it is, so we don't have to say they didn't do that.
704.4.
Yeah, 704.4, it was on page 21, I think I just said. Now I turn back to,
That's,
But if you look at all the 704s are small community, A4.
I'm,
And I'm not sure, I think that's just in the ag zone. The special provision for that should be just in the ag zone, not in the A4.
all I'm saying is they need to change one word, apartment to dwellings.
Oh, okay, I see.
And that would be in 704.4F.
Okay.
You're not looking at page 21 of the clean copy that Steve Hunter
I
sent?
am.
Okay, so it's page 21.
I'm looking at 704.4, and there's no F.
That wasn't the final, this copy. I guess you don't have it.
This is the
All
one
right.
that was sitting at my.
Then I
station
think
before the
what you would
meeting.
simply say is change under accessory dwelling, the word apartment to dwelling. Okay?
Okay.
And we'll get the numbering straightened out. All right.
So Squire Gill, you want to clarify that last, what would be included as this is the last,
So I guess that language is okay, that the above restriction shall be stated on any in-family conveyance plat and shall also be set forth in the deed transferring title to the in-family conveyance lot.
I'm sorry.
I could maybe address one thing.
Yes.
Previously, the restriction that had to be in the deed was that it had to be, the time limit it had to be held. So I think you could say the above restriction as stated in paragraph 5 must be in the deed. Well, you may want all the restrictions on the plat, but the main purpose of the deed restriction would be to let anyone looking at that deed know if they haven't held it for 15 years, then it can't be transferred outside of the family. So I think that's the one that you would want to make sure is in the deed. When I prepare a deed, that's what I do, is I state that the restriction, which is now 5 years, that they haven't held it, they must hold it for 5 years. So I think if because anyone looking at the title is interested in can this be transferred, and that's the main issue, is can it be transferred. I should have made that clearer. I wasn't thinking about that when I wrote my note to you.
So just having it in number 5 is not adequate, you want to add it in number 7 too? About,
No, I think it could say the above restrictions shall be stated on any in-family conveyance plat, and restriction number 5 shall also be set forth in the deed. Because that, once the deed has been transferred, you've got an approved plat. So the main issue is, are they holding it for the required amount of time? Which is, I think, 15 years is what you all are proposing. So, and I didn't think about that when I did this, and I apologize, but I think honestly the only thing that would need to be in the deed would be the time limitation for holding it.
so remove the last half of that sentence.
I
And
think-
add restriction number 5 shall also be set forth in the deed. After
Yes,
we
yes,
mention
ma'am.
5.
Yes, uh-huh.
Okay. So,
okay, Okay, so, we've got the basic tenets of the proposal before the court of what would be recommended from this committee to the full court. We've got about 30 minutes until we have something else that we need to attend to. And so I would encourage folks on the court that are not on the committee to engage in this discussion so that we can understand whether or not we're going to be able to make a decision from the fiscal court tonight, if this is the recommendation. But Squire Gill, this is the recommendation that you want to send to the full fiscal court, or at least the most recent version of it that you're in support of.
Right. And if it's not perfect, we can always fix it later. But the thing is, time is of essence in this. I don't know if you all got the email from planning and zoning with the number of lots that had been platted, and like in 2024 there were 37 small lots cut and reconfigured in 1 year. In the last 10 years there have been 320 something small lots configured in the county outside the urban service boundary. Most of that's in the south end where we have infrastructure issues. So this is, I think, kind of urgent. So should we make a recommendation and get a vote from the committee on this?
We need to.
Okay.
That'll be the action step, but I would like the fiscal court members to weigh in. I mean, we can take this up in fiscal court as well, but we have the time and opportunity. Squire Barney?
Thank you, Judge. I think what has been put together by the committee here and Ms. Mattingly cleaned up on the wording, I think is what we need, and I think it should be sent to the fiscal court.
Thank you, Squire Barney.
I'm not for it.
I didn't know if you had any comments. I was just.
No, I'm not for it at all.
You want to turn on your mic, Squire Brown?
Yeah, I'm not for it at all. I think it's completely ridiculous, 15 years. And I don't think we got as much problem as you think we do. It's the south end. It's mine. I ride it every day. I don't see all these lots. I don't see all these houses. We might have them one day. But I've been out there 49 years. And we just, so no, I'm not for any of it.
Thank you, Squire Brown. Squire Blackford, did you have something? Squire Taylor.
Thank you. I appreciate Squire Gill talking with me about this issue before the meeting. I want to kind of share, I guess, some of my, I've been thinking about this since I first ran on this issue and you know, some other land use conversations. And I think this is, we have to have a fix in the long run, but I do think some of my concerns with the proposal, I want to kind of talk through and see if there's any opportunity for further, because we've been good collaborators so far. The first line on the residency for the property owner for the conveyance, I like the idea of a residency requirement, but I really think it should be on those that are receiving the conveyed property, that they are going to be on the property, because I can imagine someone who maybe just lives outside the county, owns the property, they need help on the farm, their child is going to be is coming of an age, and they want to help them, they want to move back home to the area and want to help on the farm. I think really the element that we really need to entice, I guess so to say, is the utilization of this for the residency of those that are being conveyed the property. And back to the previous discussion about the original version of this in-family conveyance, that language of the clock starting with occupancy, I think that obviously I wasn't here, and I'd love to see the minutes and know more about that meeting, but I think that was an issue that that some of these abuses we're seeing weren't being done when people were building the homes on there that they were supposed to be building when they were being conveyed the property. And so obviously I think that was an effective means to that, and I think that's something that we should really consider looking at reincorporating. The second line, or I don't know if anybody has any thoughts on that element before I go to the second line. On the second line, the affidavit, I think this is a useful tool as well, but I'm wondering how difficult it's going to be on the conveyed parcel to also be a signatory on the affidavit or an affidavit compared to the primary parcel. I think that's this whole discussion about 1 to 5 acres is really kind of, I guess, goes back to that if it's 1 acre, then they can't be conveying that it's going to be used the same way for agricultural intent or agricultural use. But I do think that it gets back to the original intent of this being a small parcel for folks to live on, and we're not putting in this. I just feel like it's a difficult burden to put on someone to say you're going to have 5 acres and you need to have agricultural use on that 5 acres. I think that's a difficult burden there, and I think we could probably get the same result and actually lose less of the primary parcel to the conveyed property if we were to go to 1 acre and have that ag use affidavit just on the primary parcel. And then my third one is, again, the third line is again back to that conversation about 1 to 5 acres, and I think that 1 acre is a good use of that, and it again with the same idea of leaving the primary parcel no less than 30 acres. And the last thing I want to say is, I think ultimately we got to try to work towards a solution, but I do think that we can't ignore that the market is what's driving a lot of these loophole utilizations to try to have this increased development. And I think what we really need to look at is trying to figure out ways that we can help economically incentivize folks to keep farmland or agricultural use land, because right now the market is too enticing for someone to try to sell it to somebody who has intent to develop it. And so these farms are selling for a really high cost, and I don't want that fix to be at the detriment of the farmer that's trying to retire with dignity and grace and have some retirement security. So I think we really need to look at trying to come up with a solution on this with a PDR or some kind of economic incentive that we are purchasing development rights or an entity is doing that. I don't have an answer of how that funding mechanism comes in, but as long as the market can give them more money for a property that they think they can have a loophole in developing, then we're going to be chasing this whack-a-mole all the way around, and we're not going to be dealing with the fact that we're pricing out a lot of farmers to purchase a farm as is to be able to continue to farm. If they're paying outrageous costs for these farms, they can't make money farming on that land after they've purchased it. So that's my last piece, and that doesn't necessarily have anything to do with the explicit proposal, but I think it's a conversation we need to be having if we're going to try to deal with this issue in the long run.
Yes. So, Squire Taylor, you've brought up changes, potential changes to this proposal. Is that something that the committee wants to consider?
So, Judge.
Yeah, Squire Downey, you're recognized.
So going back, Squire Taylor, so the first, indicating that the applicant, the property owner, must be a Woodford County resident, you're asking that the conveyed owner, you're more concerned about the conveyed person being a Woodford County resident versus the current owner of the property being a Woodford County resident, correct?
And particularly becoming a resident on that parcel, right? That's what the purpose of the property being conveyed, and that they are living on that. So that would be back to that original language of the time, the clock starting for those years of restriction on the deed be starting at the occupancy of that new home.
So, yeah, that makes sense, because in theory, in this example, and I could be wrong, but I'm just talking this out, if someone owns the property, let's say a 100-acre farm, but they don't live there, they live elsewhere, but they lease it out for someone to farm, but then it comes time that their child or grandchild wants to, and they go to convey this, because they are not a resident here, in theory, they would not be able to convey that land because they don't live here, even though their child or grandchild might be wanting to live on the farm, I guess. I mean, that is a theoretical example, correct?
Could I add something?
Yes.
As to, if I understood you about the affidavit, at this point, if you read that carefully, the affidavit in a format approved by planning and zoning must be signed by the applicant, who would be the property owner, stating that at the time of the application, the parcels are being used in an agricultural manner. I think Squire Gill at the last meeting said, I don't know that we can police it after that, but we can have them state that at the time they apply, it is all being used for an agricultural purpose. So maybe given your comment, Squire, it might be that you would say the parcel is being used because you're going to have one parcel that you're trying to divide something off from. But I think that the intent there is that the affidavit would confirm that this is, at the time of division, an agricultural parcel. And also, I would just say that in this, there is, as I think you pointed out, there is no residency requirement. There is a 15-year, which is bumping it up, but there is no residency requirement at this point.
And I guess to that, again, we're not requiring them to be a farm, agricultural use in the new conveyed property. I guess since the affidavit is only at the time of application, in a way, we're not requiring the primary parcel to maintain that either. But I just think that we're going to minimize that impact on the property that may be used for agricultural purposes if we make the conveyed property a smaller property and not have the new property be the conveyed property be not fully used.
Squire Gill.
To your point, I believe at our last meeting, Squire Varner said you can put your fence anywhere you want. You can put an acre fence around your house and farm the rest of that with the primary farm, since it's all connected. So having a 5-acre tract would not stop you from farming it. You could farm it with the other parcel. That's all.
No, that's a good point. I guess after that 15 years, whether or not that the next owner might put a fence up on that 5 acres as opposed to just 1 acre is my point in the long term. Yeah.
Squire Varner.
Thank you, Judge. I understand, Squire Taylor, what you're talking about, but our goal here is to maybe stop folks from speculating on Woodford County land, and put a commitment to agriculture as a court. And but I understand where you're coming from, but I still think this document is written, or this proposal is written, gets us in that direction. Thank you, Judge.
I don't know.
Thank you. I think that there needs to be more finality in the recommendation, that if this is what we're going to do and we're going to vote on and recommend to be a part of the law, it needs to be, and I've mentioned this before, but it needs to last. It needs to be understandable. It needs to be, we don't need to go back and continue to change it regularly. It needs to be a settled version of the law that will control for as long as the previous laws have been in place to control. Small, minor changes, yes, but whatever we do in a large sweeping change needs to be something that we're willing to allow in practice to go on for the foreseeable future. Squire Gill.
I'd just like to point out that these two articles are quite lengthy. This is one paragraph. We're not addressing the A4 zone, which is a problem. We're not addressing rural residential, which is a problem. We're addressing in-family conveyance, and they had recommended that we remove it altogether. And the whole point of this is, after listening to the public, they want to keep it. And so the whole point of this is to keep it with restrictions that keep people from speculating with using this, the loopholes here, to turn a quick profit, to divide up land in a divorce, to convey land from husband and wife to wife, back to husband, which is going on right now. And that was the whole point of it. So, I mean, I think these are good recommendations. We've spent a long time on them. If it's not perfect, I don't think there's any comprehensive plan that's perfect. This is one paragraph in it. And I think it's a good start, and I'd like to recommend it to them, just so they can get the rest of those articles moving. And I would hate to wait longer, because we've had this from them. We've had their recommendation since December, I think, 20th. And I think it would be good if we got a recommendation back to them as quick as possible.
And I would just note that I am not disagreeing. This is not a disagreement. I would just say that us having that recommendation December 20th doesn't mean that what we have done has delayed or slowed down anything. In fact, we've allowed public comment, which needed to happen. Had we have moved on it in January or sooner, we could have been inclined to not seek or take the public input and then move forward, and we wouldn't have known. My guess is that I know that any sort of additional process will be viewed as moving too slowly, but the reality is that folks are going to have to digest this. And I think that the planning and zoning process will be a good opportunity for that. But I'm not sure that when these recommendations go out to the community that they're going to be, I don't know that we'll be any closer to a consensus than we were before. And I understand that that's the role of this court, to make difficult decisions. But at the same time, moving conservatively and transparently and allowing for access and public input is as important as the final decision, in my opinion. I would also say that I do think that we have to stand for farmers, as Squire Varner said. We have to do that. But I do think that there's some questions in farmers' minds as to what is the right way to do that. And so, not every farmer agrees, but I do think that most of us and most of our farming community agrees that we have to preserve productive agricultural land. We have to preserve farming. At the end of the day, the local government can't do near as much for farmers as the state and federal governments, and frankly, I don't believe either is doing enough. But we need to do more. We need to do what we can, because I do believe that we risk a large number of subdivided lots that will ultimately prohibit farming in the future. One of the things that was brought to me was the concept that a farmer could give an in-family conveyance and have the opportunity to convey that to a child or another family member along these lines, but that if they were able to sell that lot, then they'd be able to consolidate and buy a larger lot or larger piece of property to make their farm bigger. And would we consider something like that where you could allow someone to sell an in-family conveyance lot if they were to be consolidating a farm into a larger farm? If that was the financial impetus for them to grow their farm. I don't know that that happens very often, but that's a good point. I mean, if we wanted consolidation of farmland and larger platted acreage, that could be a potential way to do that. And at least this would be restrictive in allowing them to do that. But I'm sharing a comment that was shared with me recently. So that being said, Squire Downey?
Squire Taylor, going back as I'm thinking, and I may be thinking about this wrong, about the conveyed individual being a Woodford County resident, if a daughter, son, or grandchild is not living here, but they are getting conveyed that property, they, in theory, would not be a Woodford County resident until that is conveyed, right? So would that be prohibiting them from taking over that convey? That
As it's currently, or
what you were proposing, if you were, right now, the proposal is that the applicant, the current owner of the property, be a Woodford County resident that owns the 100-acre farm in this example. They want to convey it to their child or grandchild who does not live in Woodford County, but is intent on building a house and moving there. If they are not a Woodford County resident, theoretically now they live in Lexington, if you're saying they have to be a Woodford County resident to receive that, then that would prohibit them.
Yeah, I guess what I'm saying is not that it would have a residency requirement itself. It would be that the clock for the years of the restriction on the deed of that 15 years would only start when they became an occupant of that. So I would, you're right, I kind of maybe was misleading in the way I said that unintentionally. Really, it was what I was pointing out is the fact that it's been expressed to us that the intent of in-family conveyance is to give a parcel to their loved one to live on that property, and let's follow that step through and ensure that they're actually living on that property and not just sitting on it, because to the point of speculation on farm property, land is only going up in value, and so even if they convey it and they have to hold it for 15 years, it's going to increase in value, and there's still no necessarily commitment. Even if it's 20 years, there's still no necessarily requirement that they live there. It's still a good financial investment to them, and it's not fulfilling the intent.
Where so looking at option 5, at the 15-year clause, are you recommending a occupancy that the 15 years would not begin until occupancy of?
Until there's a certificate of occupancy on the residence on the conveyed property.
Squire Gill, I mean, I would be open to that consideration.
I'm not sure how to word it in number 5. Anybody have any suggestions?
I don't know what the original language was on the original ordinance, but that was included in there. We might be able to find that.
As far as the original, going back to 1990, requirement was that a parcel conveyed to a family member they would reside on the property for at least 5 years. So the limitation was 5 years. After 5 years, if they had built, they could sell once they had resided there for 5 years. The ordinance was later changed to where they only had to own the tract for 5 years. Mm-hmm. So the residency was removed. Speaking to Squire Taylor's comment, it does and I'm not making an editorial here, but the in-family conveyance, it does seem like from the comments we've heard, that people want their children, their child, their grandchild to live on the property next to them. So it does seem to make sense that there would be a residency requirement. And if there was a residency requirement, then if you might then want to go back and say, should that be for 5 years, 10 years, 15 years? And whatever you would decide there would be the court's decision, but it would be tied to residency as opposed to just owning the tract.
And how would you put that in there? Because we're about out of time. We've got 5 more minutes.
The original email you sent us had some language on that. I don't.
Got to go back and look at that. I can find it. I apologize. Let's see. My recommendation was, let's see.
Here we go.
It was that.
Oh, and the email you sent.
It was that, I've got it here, the in-family conveyance parcel must be held and resided upon for a minimum of, and I'll leave it up to you, how much acreage, years, I'm sorry, before a sale can be made, or a transfer could be made. The in-family conveyance must be held and resided upon for a minimum of blank years before I would use the term transfer can be made.
So, based on that, I think we had a 15-year proposal. The original was 5. That was removed, or the residency was removed from that piece. I'm just splitting the difference and saying if resided upon in 10 years, then that way you're somewhere in the middle there and is before a transfer rather than a sale. Mr. County Attorney, is that what you recommended?
I think any transfer by deed would be,
So would it be enough to say that the conveyance lot must be held and resided upon for at least 10 years? Is that what you're saying?
For a minimum of 10 years before a transfer can be made.
Without transfers. Okay, and the way she's written this, and just to add as few words as possible, we could say both the primary parcel and the in-family conveyance lot must be held and resided upon. Well, no, we're just talking about just the conveyed parcel must be resided upon for at least 10 years without transfers after recordation of the deed conveying the in-family conveyance lot.
now, and you have the exception to that it can always be conveyed back to the original parcel.
Right,
You
and
have
that's
that.
in there
And
too.
then- So if, for example, I have a farm, I deed my 18-year-old a parcel, and they have to reside on it for 10 years, let's say, and they decide later that they're going to move to Timbuktu, and they don't need it, then they could convey it back to me, and that would be okay.
Okay. Okay. So, do you want me to read the final, or do you want to?
I'm okay. I mean, if you're okay with that, I'm okay with that.
Okay. Special provisions for in-family conveyance. Number 1, the applicant property owner must be a Woodford County resident. Number 2, an affidavit in a format provided by Planning and Zoning must be signed by the applicant stating at the time of the application all parcels are being used in a manner consistent with Article 201 agricultural use of the Woodford County zoning ordinance. Number 3, an in-family conveyance shall not be approved on a farm parcel less than 35 acres. A farm parcel of 35 to 49 acres shall be eligible for 1 in-family conveyance. A farm parcel 50 acres and above shall be eligible for 2 in-family conveyances. Number 4, an in-family conveyance lot shall not be less than 5 acres, platted with legal frontage touching a platted right-of-way. Number 5, both the primary parcel and the in-family conveyance lot must be held and resided upon for at least 10 years without transfers after recordation of the deed conveying the in-family conveyance lot. Exceptions to this restriction shall be a transfer between the parties of the original in-family conveyance and a forced sale due to judicial action. Number 6, an in-family conveyance lot can only be conveyed from a parent to a child, natural or legally adopted, or from a grandparent to a grandchild. And number 7, lastly, the above restrictions shall be stated on an in-family conveyance plat. Restrictions in number 5 shall also be set forth in the deed.
That's your proposal, you'd like to
I make that-
recommend from the committee to the full fiscal court?
Yes, I make that motion.
There's a motion?
Second.
There's a second. I just note that, I don't know that I'm prepared to cast an aye vote. I'm in favor of most of the things that we're trying to do. I'm trying to make sure that the fiscal court's prepared and the public is ready. That's my comments. Other questions or comments? Anybody from the fiscal court not on the committee have any comments or questions? Seeing none, there's a vote on the table to recommend to the full fiscal court the amendment to the proposed ordinance changing to the in-family conveyance language to be sent to the planning commission as set forth. Are we prepared to vote? All those in favor say aye.
Aye.
All those opposed? Nay. Let the record reflect that the motion carries. And there is no more business to come before the committee. We will reconvene in fiscal court at 5:30.
For this opioids things, and they're going to honor the cheerleaders in the community room. So if you want to go down to that. Right.